with me, civil attorney, former prosecutor Kirk Davis. Phew, Kirk, I'm exhausted because during this you learn a lot about these jurors, and it really appears to be an educated group of people who believe that they can set aside any previous assertions in the case and can consider the evidence as it's presented. In your opinion, are there any disadvantages to having the very analytical minds on the jury?
Well, I think that's a great question, Judge Ashley. I think that probably both sides are thinking that emotion will come into play a little bit. I mean, you have sort of natural built-in reactions, no matter who you are when you see the video. And I think most of the jurors had seen at least some or parts of the video. So what is the danger of having a juror who is overly analytical? Perhaps the state may be thinking, well, they're going to pick apart this evidence to the point where there's nothing really that is questioned. They're given the instruction of the state has the burden to prove that case beyond a reasonable doubt. And perhaps when you get somebody that's too analytical, perhaps the concern is that they're not going to be satisfied with what gets presented.
And you make an excellent point. Of course, this is a case raw with emotion for all of the reasons that we know, and the death of George Floyd. But bottom line, what you just said is true. The state has the burden. Chauvin's presumed innocent. So one of the other aspects that I want to discuss about one of the jurors or some of the jurors is, what about those who have professions that put them in contact with people suffering from physical trauma or mental health issues? And for instance, juror number 118, who's a social worker, I want to listen now to what she had to say about mental health and police training.
You were asked a question whether you or someone close to you has ever supported or advocated in favor of or against police reform, and you wrote, family members have discussed support of both. What do you mean by that, and how does that, what was the general tenor of the conversations on both sides?
It was typically focused on training in response to situations of like mental health or things like that, having more specific mental health and not so focused on what seems like a presumption of guilt right away, that sort of thing.
Talk a little bit about this. I think that what that offers is the empathy. I think that jury members like these are going to be very empathetic, and they've got that type of training. But tell me, in your current experience doing civil suits as well as a former prosecutor, does that cut both ways, that empathy for the defendant or empathy for the victim?
I think that's a great point, Judge Ashley. I really do, because both sides have obviously thought about the kinds of jurors that they want. Perhaps they've even done focus groups where they bring people in from the community and sort of give them a test run of the evidence and see how certain people react. Perhaps they have a certain idea in mind. And then you get to present this evidence to the jury. And if you have someone that is very empathetic, perhaps they are going to think, well, look what happened to this poor man, George Floyd. And then on the other side, perhaps they're going to think, well, now what's going to happen to the police officer, Chauvin, once we convict him? Or if we do convict him, what is going to happen to him and his family? So I absolutely agree, Judge Ashley. I think it can cut both ways there.
And is that affected by how many times a jury now at this point that they've been seated, but that a juror has seen the video? And I want to first play and then come back to you on this question. One of the jurors who may not have seen the video. Let's listen.
In your questionnaire, you acknowledge that you've seen a Facebook video or certain videos of this incident, right?
I have not seen the video.
Oh, you have not. I'm sorry. I had to flip my page. So You've not seen any of the social media videos or news stories with clips of the video or anything?
No.
Okay.
I've seen the still, there's a still image that was pretty common, but that's the most I've seen.
Okay. Thank you for that clarification.
All right, Kirk, so the empathy you were just discussing, and I loved your insight on that, is that affected by how many times these jurors have seen the video, or this juror who says, I've never seen this video?
I think, again, great question, Judge Ashley. When you first see that video of Mr. Floyd on the ground with the knee of the officer on his neck, it's just horrifying. I mean, you just can't get beyond that. It's really disturbing. So if you're the defense and you're thinking, what do we do here? I think you probably want, as strange it may sound, I think you probably want those jurors to have seen this video to sort of take away some of that initial impact, that emotional impact that video has. Yeah, I think if you haven't seen that video and you're seeing that for the first time when you're coming into trial, that is going to have an effect.
Boy, Kirk, that's such a great point that I hadn't thought of, but you're right. I think the first time any of us saw that video took your breath away. And it's, gosh, the emotion that evokes the very first time you witness that. Excellent point. So I want to shift gears a little bit. We're talking about the pressure on the jury, and Judge Perry was interviewed earlier today by Julie Grant, and I want to play a little bit of what his thoughts were around the number of alternates that have been selected. Let's listen.
I would be extremely nervous if you go back and you look at cases that are high profile. The O.J. Simpson case and other cases, they lost jurors at a rate of 1 a week. If you have a trial that's going to last, you can count on, unless you're extremely lucky and blessed, to lose jurors. And then once you get below a certain number, unless the defense is going to stipulate to having less than the required number, you're going to have to start all over again.
And that, to me, puts a lot of pressure on this jury. But do you think they know or they realize that we only have this many alternates? And as we get into it, I really have to sit for this whole trial, right? Barring some big emergency unforeseen that changes that. What pressure? What do you think about the number of alternates that they are going to have for this caliber of a trial?
I was surprised. I was very shocked to hear that they're just going with a couple, 2 to 3 alternates, given the length of the trial that they're expecting here. I mean, they're expecting this trial to go for several weeks. So, and like the judge we just heard from, excellent point that people can get sick, especially during the time with COVID. It seems like it might have been wise to have a couple more folks as alternates. I don't know if there's some sort of space considerations again with COVID or what the thought is there, but it seems to me it is taking a risk. Certainly, if you can't have all the jurors that you need, the 12, I mean, potentially you could wind up with a mistrial.
So that's the next legal point I would love for you to speak on before we have to take a short break. And that is, Kirk, what happens if they run out of alternates during the trial? What happens, to the trial?
Well, if they get below 12, then I believe, certainly in my state here, in the state of Washington, then the defense could move for a mistrial. And I believe that the judge would be very hard pressed to avoid not giving that mistrial. So the whole thing, the entire jury selection, all the motions, potentially everything, you start all over again. That would be a really hard thing to go through for everybody, for Mr. Floyd's family, for everybody involved in the case.
Absolutely. Kirk, I can't thank you enough for being with us and all your wonderful insight. Thank you so much. Up next,